Some people think that if the US citizen sibling files a family petition for the immigrant sibling is protected while the petition is pending. That is completely false for a variety of reasons. And by the way, even for like spouses right now under the Trump administration, it's not completely true that you're protected. But forget about spouses because siblings are way less protected. There's a lot of misinformation out there about sibling petitions, so this video is to set the record straight. I created a really detailed video on sibling petitions a couple years ago, and it did really well when my channel was still very tiny, and the comments clearly showed that this was all new information for a lot of the people. So if you have a sibling petition pending, or you have a sibling for whom you intend to file a family petition, check out this video before you do. Or if you already have one pending, you should also check out this video because it'll manage your expectations for what you should expect in the future. So there's two situations that I see generally. One is a sibling is in the United States and has a US citizen sibling. So an immigrant sibling is in the US and has a US citizen sibling who wants to petition for them. That US citizen sibling has to be over age 21 in either scenario. And the other scenario is the US citizen sibling's in the US and the immigrant sibling is outside of the US, probably in his or her home country. Let's talk about the first situation where the US citizen and the immigrant siblings are in the US. Some people think that if the US citizen sibling files a family petition for the immigrant sibling is protected while the petition is pending. That is completely false for a variety of reasons. And by the way, even for like spouses right now under the Trump administration, it's not completely true that you're protected. But forget about spouses because siblings are way less protected. A sibling petition of this type is referred to as a preference category petition. When you're filing a preference category petition for someone who is out of status in the US, they cannot apply for adjustment of status in the US. They will eventually have to leave the US and consular process at a consulate abroad, and then they could re-enter the US with an immigrant visa. So for example, if you are a US citizen and your sibling is in the US unlawfully present, maybe they entered on a tourist visa or they entered through the border or something, whatever, they're unlawfully present here, you can file a family petition for them, but that's not gonna protect them while they're here unlawfully present. And it's not gonna allow them to apply for a green card from within the United States. In the best case scenario, they'll have to leave the US and then re-enter with an immigrant visa, which is also probably unlikely to happen, which I'll explain. The second problem with these petitions is that the processing time takes like 17 years before a visa becomes available. I should have probably started with that one. That's a big problem for a lot of people. So if I file a petition for my sibling, we can't continue to the second step in the process, which is not the last step, until 17 years have passed, around 17 years, and a visa becomes available. You can check out the processing times by just Googling the US Department of State Visa Bulletin, and then go down to category F4 for the fourth preference category petition, and you'll see they're currently processing applications from like 2008. So someone who filed a family petition in 2008, today in 2025, they can continue to the next part of the process. And the final major reason why it's not what people think it is, doing it from within the US, let's say your sibling is out of status and manages to wait the 17 years until the visa becomes available. Well, now, as I said before, they have to go to a consulate abroad for the interview so that they could re-enter as a permanent resident, but they can't because they have more than 1 year of unlawful presence in the United States. So the moment they leave to go to that interview, they're gonna trigger a 10-year unlawful presence bar that prevents them from coming back. The only way that they can avoid that situation where they're barred from coming back at the consulate is if they apply for an unlawful presence waiver while they're in the United States. This can be achieved by filing Form I-601A. However, to do so, you need to have a spouse or a parent who's a permanent resident or a US citizen. And you need to demonstrate that your inability to re-enter the US after your interview is gonna cause them extreme hardship. But you don't have a spouse or parent who's a permanent resident or citizen, because if you did, you wouldn't be doing a sibling petition. You would have that family member file a petition for you because that category is much faster. Still can take like 8 to 14 years, but still faster than 17 years. I see a lot of people right now who entered the US through Biden's humanitarian parole programs, and they're losing their status or their TPS is about to expire and they're desperate. And a lot of them have family here or siblings here. And I see them filing these petitions and then they come to me afterwards like, hey, can I file the adjustment of status application? And I have to break the news to them. Like, you probably wasted your money by filing this sibling petition. This is not gonna protect you from deportation during the Trump administration. And it's probably not even gonna protect you for the next 3 presidential administrations as well, because it's gonna take like 17 years before you can even take the next steps on this, and you might not even have options if your family member is still unlawfully present in the US. I also see a lot of situations where people are filing sibling petitions for siblings who are abroad, and that's okay. They will eventually probably be able to immigrate to the US, assuming the petitioner, the sibling who's a US citizen, stays alive for that long. If the petitioner dies, the petition dies with them. And this actually happened to my family. My grandfather, who was a US citizen, filed petitions for a lot of his adult sons and daughters. That category of petition at the time was taking around 13 years because the adult sons or daughters were married, so it's a long, lengthy process. My grandfather dies before those 13 years pass, and all of those petitions died with him. What we should have done was had both of my grandparents file the petitions because they were both US citizens. And so if one of them dies, the petitions continue with the other one. Again, this isn't a sibling petition, but the principle remains the same. If the petitioner dies, the petition usually dies with them unless you qualify for something called humanitarian reinstatement or a similar program like that, which is possible, but definitely not guaranteed. All right, guys, I hope that answers some questions that people may have had about filing a sibling petition. For those of you who do want to get started on the process, my office can assist you. My office and I focus on family-based immigration, so that's our bread and butter. It's what we do all day long. It's what we love to do, and it's what we focus our practice on. We also assist with naturalization applications and deportation defense. So if you need assistance with any of these matters and you want to speak directly with me, Puyan Darian, I handle these cases nationwide and I am an immigration attorney. You could schedule a consultation by clicking the direct booking link in the video description below, or you can go to my website, darianlaw.com, to schedule a consultation there. Thanks so much for watching, guys, and I'll see you next time for another video.